I can. Thank you, Mr. Lacy.
Yes.
All right. This is your motion. So, if there's anyone else you wish to identify for the record, feel free to do so. Otherwise, you have the floor.
I assume some of my clients have tuned in by Zoom, but I can't identify which specifically. So I'd just like to proceed, Your Honor.
Sure. Go ahead.
In reality, this is a fairly straightforward motion under CR 15. Normally, I wouldn't have had to even file it, but because of Scrivener's error, I had previously amended my complaint, and therefore this becomes the second amended complaint. Otherwise, if it were a First Amendment, I would simply have filed a motion or done it without leave of court. Wouldn't have had to file a motion. I think the arguments first of all, I want to ask the court, did you get my recent short reply that I sent to Joe?
I did. I have it in front of me now.
Okay. And if the court has read the pleadings on this, I think my approach would be to defer to Mr. James and then simply respond to his arguments as to why leave to amend should not be granted.
All right. Thank you. Mr. James, you have the floor.
Good morning, Your Honor. Plaintiff's motion presents two issues for the court to resolve. First, should plaintiffs be allowed to submit their proposed second amended complaint, which contains but one minor modification from their current first amended complaint? And secondly, if the court denies the request to submit the proposed second amended complaint, should plaintiffs be permitted to go back to the drawing board and start over? We submit the answer to both questions is no, and that the appropriate action at this point is to dismiss this matter with prejudice. Plaintiff's proposed second amended complaint suffers from the same defects as the first amended complaint. This issue was fully briefed and argued, and the parties await the court's ruling. At best, plaintiff's motion at this point is premature in that it presupposes that the court lets the first amended complaint proceed. At worst, it is a needless waste of resources. The only changes to the first amended complaint that plaintiffs are proposing are nonsensical and come nowhere close to meeting the requirements of CR 8A. They propose to change the caption from, quote, perceived disability discrimination, close quote, to, quote, disability discrimination, quote, which by itself does nothing to change the underlying allegations that are actually pled. They do not propose to add a cause of action for religious discrimination, yet they lump references to religious exemptions into their claim for disability discrimination. As the court knows, a person's religious beliefs have nothing to do with whether they are disabled or whether they are entitled to medical accommodation. But apart from this change to the caption, the only proposed change to the allegations pled by plaintiffs is to add a phrase to one sentence in paragraph 13, which reads, quote, and or constituted a failure to accommodate their claims for accommodation based on medical or religious exemption in violation of RCW 496180, close quote. Now, from their briefing, we can glean that they mistakenly believe that this phrase is sufficient to state individual claims for religious discrimination, actual as opposed to perceived disability discrimination, failure to accommodate a sincerely held religious belief, and failure to accommodate a medical disability. But as pointed out in our response, the proposed second amended complaint fails to meet the minimal notice pleading requirements of CR 8A. You cannot group plead these types of claims as they will vary from individual to individual. Defendants cannot defend against individual claims of disparate treatment and failure to accommodate without knowing who's making the claim and some details of the wrong they claim to have suffered. So accordingly, the court should deny plaintiff's proposed second amended complaint as failing to state claims for which relief can be granted in accordance with CR 8A. Let me turn now to whether the court should send plaintiffs back to the drawing board or dismiss this action with prejudice. I will also address some of the arguments put forth by plaintiffs' counsel in their reply brief. Plaintiffs have the burden of pleading sufficient facts which, if true, would establish a prima facie case for each individual plaintiff. They cannot rely on discovery to satisfy their minimum pleading requirements under CR 8A. And CR 15B does not apply here because there is no evidence in this case on which to conform the pleadings, as they assert. All that is before the court beyond the arguments of counsel are plaintiff's pleadings and plaintiff's concession made in oral argument and in their briefs that those pleadings do not include claims for religious discrimination, actual disability discrimination, failure to accommodate a sincerely held religious belief, and failure to accommodate medical disability. Plaintiffs attempt to flip-flop and claim their original complaint included these claims, as well as their attempt to pass off the latest version of their complaint as setting forth these claims, is vexing in that they've now had 3 opportunities to get it right. It's not difficult. All counsel would need to do is interview his clients and then include a short, plain statement setting forth the claim of each individual as outlined in our brief. Either they cannot do so, or they are refusing to do so for strategic or political reasons. But meanwhile, they are wasting the court's time and causing my clients unnecessary legal fees. Plaintiffs assert that if the court denies their motion, they could simply file a new action asserting claims for religious discrimination, actual disability discrimination, failure to accommodate a sincerely held religious belief, and failure to accommodate a medical disability. We believe they are mistaken, but be that as it may, the court should not avoid issuing a proper ruling based on plaintiffs' speculative assertions. The court has the inherent power to put an end to this and dismiss the matter with prejudice pursuant to 12b-6, leaving plaintiffs to make their arguments to the appellate court. There's no reason to believe that plaintiffs will correct their pleadings if this court were to give them a 4th opportunity to do so. And therefore, we respectfully request that the court deny them leave to amend and dismiss this matter with prejudice at this point. Does the court have any questions for me?
I may at some point, but for now, I don't. Thank you very much, Mr. James. Mr. Lacey, you have the floor.
Thank you, Your Honor. Let me address first the insufficient specificity argument. This second amended complaint before the court clearly apprises the defendants of the nature of the claims being asserted. The first claim, of course, discharge in violation of public policy, is not really before the court here, but it is under advisement. The disparate treatment disability claim was pled previously and argued. It's under advisement. Both of those claims are sufficiently pled within to put the defendant on notice. And I submit to you that by stating specifically that my clients were denied an accommodation based on medical or religious grounds, that is sufficient to apprise the defendant of what the claim is and what the legal status or what the legal reasoning for that claim is, because both of those categories are categories under RCW 4960 180, and 4960 180 is pled specifically in the complaint. So the legal grounds on which the claims rest for all 3 causes of action have been stated in the complaint. In the wrongful discharge case, it's basically a common law cause of action and it's based on the case law. The other 2 are based on 4960 180, and all the complaint really has to do is indicate that there's been a violation of the statute, and that pretty much puts the defendant on notice the fact that they will have to defend upon the case based on the elements to prove that cause of action under 4960 180. So this idea that counsel seems to be advancing, that we have to be more specific than that and go more in detail into the facts of the case and aver every specific aspect of the case that we intend to prove, is clearly not in keeping with the case law, which the court which they cited to the court, and which I'll get to in a minute. Their next argument with respect to specificity is that the complaint, this is a complaint, as the court knows, it's pled in the alternative as a class action lawsuit if certified, and in the alternative as an individual claim on behalf of each named plaintiff in the case. So if the court, which we haven't got to that point yet, but if the court decides that this is not a proper case for class action status, the issues or factual or legal issues are not sufficiently in common, and employs the other factors for establishment of a class action, and decides that these cases should be brought individually, I have pled them individually on behalf of all individual plaintiffs. So there really isn't any argument, as stated in the brief by counsel and in his argument today, that we haven't specified to them who the plaintiffs are in these cases. Each one of these plaintiffs is alleging, under the amended complaint and under the previous versions of the complaint, they are all alleging the same cause of action, each of them. So, but what the defendant wants us to do, and this is nearly physically impossible to do, is to take 92 plaintiffs and specifically go into the facts in the complaint on each plaintiff and make averments in the complaint that are specific to each plaintiff, so that the defendant is apprised in the complaint that specifically what we intend to argue with respect to each plaintiff in proving those causes of action. I've never seen any case law, and the defendant certainly hasn't submitted any, that says that a complaint has to be that specific in order to meet the pleading requirements in Washington, which simply it requires us to apprise the defendant of the nature of the claims and the legal grounds upon which the claims rest. In this case, in particular, to do what the defendants ask us to do or suggest it has to be done in terms of specificity in the complaint would probably result in a complaint somewhere between 40 and 80 pages long in order to address each of the 92 plaintiffs and their specific factual circumstances with respect to this. The argument that the defendant would make, well, we don't know which plaintiff claims a medical exemption or which plaintiff claims accommodation based on a religious exemption, or which plaintiffs, and there were a few of them, chose not to submit religious or medical exemptions because they were put in a position where they understood that would be futile, since the announcement had already been made by Confluence Health that they would be fired in 90 days after being put on an unpaid leave, even if they did so. And there are arguments to be made, and I certainly intend to make them legal arguments as to why the first element of the claim, in terms of the statement of the claim of the exemption, should be waived and should be waived in circumstances of that kind of constructive discharge. But for now, all I need to allege is that each of them is individually stating those claims, and that is clearly within the complaint. Generally, and I think if the court has read the case law that's been cited, generally the basis that a court relies upon for denying an amendment to a complaint is that the cause of action or the grounds upon which the plaintiff seeks recovery would create some kind of unfair prejudice to the defendant. But it's clear from the cases that the defendants have given the court, and I detailed this in my brief, that the cases in which the courts have been upheld in the exercise of the discretion to not allow the amendment of a complaint have been cases in which it was clear that the defendants could have had a basis to claim unfair prejudice based upon timing. For example, in the case law that was cited, where one of the parties decided that he was going to try to amend his complaint more than a year after the complaint was filed, after it was at issue, and when there were 3 months of discovery before the discovery cut off and 4 months until trial. That was the Sidorous case, I think. The other case that was cited was a similar case where the unfairness of allowing an amendment to the complaint was evident because the parties had gone so far down the road in litigation. In this case, the defendants haven't even filed an answer to any complaint. The case is not even at issue before the court in the sense that there are no complete original pleadings in this case, and there is no basis upon which to determine that there would be some kind of unfair prejudice or surprise to the defendants with respect to these claims that I'm wanting to add to the complaint. For example, in this case, as the court remembers, on July 21st, even though they and Mr. James and I both agreed ultimately that the complaint was probably insufficient to state a claim for a failure to accommodate based on religious or medical exemption denials, that he went ahead and argued that case anyway, recognizing the possibility from the facts in this case that such claim could be asserted. I objected. In fact, his statement today that was, I think he said, fully briefed and argued, is entirely inaccurate. The court may recall that I objected to allowing him to fully argue with respect to the question of the cause of action for failure to accommodate medical or religious exemptions because they hadn't been pled. And I also pointed out to him and to you, Your Honor, that in some future date, we might be amending the complaint to include those claims. And if we did, that would be the appropriate time to fully brief and argue those claims. And all that's happening now is that I have decided to add those claims to the case. And that's not that unusual, especially in a situation where there hasn't been an answer filed and there is no discovery been commenced and we have no trial date. The defendants in this case really are arguing substance over or procedure over substance. They want the court to basically go back to the old days and talk about vermins and analyze specifically the particulars of a complaint in order to find out if they agree that with the way in which the plaintiff stated their claims. But it's clear in Washington, you don't have to consider that. You don't have to find out or decide how artful a drafter I am. You just have to determine that the complaint is sufficient to put them on notice of the fact of what the claim is and what the legal basis upon which it's being brought is. And that this complaint clearly does that. I think I'm hearing, and at least in the briefing by counsel, I don't think he really argued it today, but he's maybe also making some kind of waiver or estoppel argument suggesting that my clients, because of my statement on July 21st, that the original complaint, the complaint before the court at that time, didn't state a claim for medical or religious accommodation, that means that medical or religious accommodation claims could never come up in the case because they'd be prejudiced if I were to state at one point that the complaint did not contain those claims and then go ahead and try to assert those claims before they filed an answer, before a trial date, before any discovery had commenced. They don't cite any authority for that, of course, because there couldn't be any. That's kind of a ridiculous argument. This is really, despite the artful way that Mr. James has framed his argument, this is really kind of a no-brainer with respect to a CR-15 motion. I suspect that they just don't want to face the argument that they failed to accommodate these people because their accommodation was putting them on a 90-day leave without pay and then firing them, and they probably are worried that that would constitute result in a decision either by a court or a jury that accommodation was not appropriate or sufficient. But that's all pled in the complaint, all of those facts. And And then finally, I think I want to just discuss this last issue, which is kind of a bootstrapping argument that counsel makes. He says you ought to take the opportunity on a motion to amend the complaint to dismiss the cause of action with prejudice. I've never even heard of that. Maybe he doesn't say any authority that a court could simply dismiss a cause of action with prejudice because the court decided, based on the state of the pleadings, not to grant a motion to amend. In essence, what you'd be doing was shortening the statute of limitations in this case by about 1.5 years or 2 years, which I haven't seen the authority for a court doing that either, without analysis of the facts and an opportunity of the parties to argue the facts. And we haven't even had any opportunity in this case to argue the facts of these cases. We spent now months since, I think, May or so, when they filed their 12B6 motion, waiting to see if we were going to get to do discovery in this case and go forward. There are no sufficient facts or any facts upon which the court could make a factual determination sufficient to dismiss this action. That's my argument.
Okay, so Mr. Lacey, it sounds like there's no question that the proposed second amended complaint would add new claims for failure to accommodate based on medical or religious exemptions, correct? New claims have been added.
That is the purpose. Well, no,
right.
No, let me restate that. It depends on how you define a claim. I don't want to mince words with the court, but it's not stating a new claim, it's stating a new legal theory on the same facts. Now, if that's what you mean by new claims, then I agree. But basically, we're saying that there's an additional cause of action available under the same facts, and now we're pleading that cause of action.
All right. Okay. I realize this is actually Mr. Lacey's client's motion, but because of where we're at procedurally, the posture of the case, I'm going to give the last word to Mr. James. Mr. James?
Thank you, Your Honor. I think the last point that Mr. Lacey made is a good place to start, which is talking about facts. There are no facts that are pled. He's said that he's asserting a new claim under RCW 4960, but he has not pled the facts to establish that each individual has such a claim. And most importantly, he hasn't pled that they have standing to assert such a claim. Without at least a short, plain statement with respect to each individual defendant, stating that they either applied for an exemption, if they applied, what was it based on? Did they have a sincerely held religious belief? Or did they claim to have a medical disability? Did they receive an accommodation where they denied it? And was there something that was unlawful or unfair about that? Without that, what he's saying we would have to do is guess. And that is not what the rules require. He's saying that we would have to go and take over 90 depositions just to find out if someone is actually asserting that claim. And that is preposterous. That's why we are at this point. And that's what we are asking for, or have been asking for in our prior motion, was just lay out the simple facts. Judge Rice dealt with this issue and denied similar claims based on a lack of standing because people had not pled. They actually applied for an exemption. And what we're left with is Mr. Lacey's complaint that includes inconsistent allegations. Some people had moral objectives. Some people had intellectual objectives. Some people didn't apply. So there's an admission right there that some of the plaintiffs can't have standing and they should be dismissed. But you, as the court, can't decide which plaintiffs those are because he hasn't identified them. Now, he tries to say this is pled as a class action, but I would submit to the court, he has not identified a proposed class representative. He has not said whether that proposed class representative has standing, whether they're a class representative based on religious or medical issues. And so we are left just guessing, not having the most basic things that Washington rules require as far as a pleading. How is it prejudicial to us? Well, first off, no defendant should be in a position of trying to know what they're supposed to defend against. And secondly, his failure to plead these things, as we've submitted back on July 21st, and as we're submitting today, renders his complaint futile. I said the issue was fully briefed and argued. I did not mean the issues of whether or not he had stated a claim for religious or disability discrimination. I meant, what are the requirements for proper pleading under CR 8? Had he met those in his original complaint? We submit he is not. We are awaiting the court's ruling on that. I won't re-argue those issues, but that's what I was referring to at that point. Without something, we can't defend. And it's not that difficult as I've submitted. So the court, most definitely, we submit, should deny this second proposed amendment. And the second question that we asked of the court is whether you should dismiss the entire matter with prejudice under 12b-6. There's a motion pending before the court. The court has that authority. We submit that would be an opportunity for the court to move this to the appellate level.
Your
All
Honor.
right. Yeah, go ahead, Mr. Lacy.
Well, again, as the court indicated, I deferred portions of my argument, basically my argument, to make a response. You've given him another opportunity when he's raised some new averments or arguments that I'd like to respond to. It won't take me long.
Go ahead.
First of all, he alleges that the posture that they are in would require them to take 90 depositions. And I suggested to you that that is not true. What is true is that for every plaintiff in this case who sought an exemption, medical, religious, or otherwise, there's a record created that is possessed by the defendant, Confluence Health. They have all the records. They know exactly who applied for exemptions. They know which ones were granted and they know which ones were denied. And they don't need to take any depositions in order to make that determination. And number two, there are named class representatives in the complaint. We named basically all 92 as class representatives, and we would certainly not have any problem with picking and choosing one or two if they want to limit the number of class representatives in the case. But the complaint simply alleged that they all were in a position to be class representatives. So that's just not a true fact. That's all I have to say.
Okay, thank you very much. So I have never, well, let me start with Rule 15. Rule 15 is the rule that governs amendment of a complaint. And that rule specifically provides that leave to amend shall be freely given when justice so requires. As Mr. Lacy rightly points out, most, or I think all of the case law that's been cited or brought to my attention involved, at least involving denials of a motion to amend, involved cases in which a trial date was imminent or discovery had long since been underway. And there was some reason why we were so, the procedural history in that particular case was so far down the road that it made it unfair. And justice did not require that leave to amend be freely given. So I'm going to grant the motion to amend under Rule 15A because I think the rule is pretty straightforward. Leave is to be freely given when justice so requires. So that part of it's handled. The odd procedural posture that we're in, however, is that the defense's motion to dismiss has been, the briefing's been submitted. We've had an argument. I'm currently working on the letter ruling. So it is a bit odd procedurally to add the new claims as Mr. Lacy and I discussed here today, while the letter ruling is under, or the ruling is under advisement. So my question then becomes, Mr. James, I'm hearing you say that your client wishes to include, to the extent there are new claims asserted in the, or new causes of action asserted in the second amended complaint, your client's going to seek to bring a dispositive motion under Rule 12 and or 56, correct?
That is correct, Your Honor.
How much time does your client seek to respond to the additional claims?
If we could have another 2 weeks to submit briefing on the new claims and add them essentially to our 12B6 motion or to our motion to dismiss, I believe that that should be sufficient for us.
So just to keep things nice and simple, how about we pick close of business September 23?
That would be fine. Thank you, Your Honor.
And then Mr. Lacy, I don't want to short you on your opportunity to respond. And by the way, I'm inclined just to keep the case moving. It may seem like things are moving slowly, but there is a lot of material to paw through. And I'm inclined to hear the issue without oral argument. And frankly, I'm kind of debating whether even a reply brief is needed. There's been enough briefing and so forth submitted so far. So I'd be willing to hear from the lawyer, Mr. James, particularly on the reply brief issue, but I'm inclined to go without oral argument. But I'm wondering, Mr. Lacy, how much time after the 9/23 deadline for Mr. James's materials, how much time you might feel you need to respond?
10 days would be sufficient, Your Honor. Or in that neighborhood.
Okay, how about, so that would be a full week would be to the 30th. So we'll then dip into October. Why don't we just go to October 7th? That'll give you a full 2 weeks. We'll say close of business on 10/7.
All right.
All right, Mr. James, and that's a little bit more time than Mr. Lacy requested, but I'm trying to kind of keep things straightforward and simple by way of deadlines. Mr. James, what are your thoughts on a reply brief?
Well, respectfully, I don't want to add to the court's burden, but I also don't know if Mr. Lacy would raise arguments that we would feel compelled to bring to the court's attention. So respectfully, if we could have the opportunity to submit a short reply brief, at least, 3 days after getting his response, and if we could have a full week, I would greatly appreciate that.
All right. One thing I always enjoy is to hear arguments from good lawyers, and that's what we've got in this case. So it'll be a pleasure to hear whatever these lawyers have to offer on the case. So, and seriously, the briefing is helpful. It's not an extra burden. It can help unlock some ways of looking at things and some new perspectives, and sometimes citation to good legal authority, and that's what we follow in this court. So 10/7 is the deadline for Mr. Lacy's response. We'll go to 10/14. There's a holiday in there on the 10th, but we'll go to 10/14 for the reply. And thereafter, what I'm going to do is just add these arguments to the matters that the court is already working through, and we'll probably issue a letter ruling on all of the issues all at the same time.
All right. So if I'm understanding the court correctly, Mr. Lacy, there's a inclination on the part of the court to rule at this point without further oral argument, which I frankly agree with. There's really no need for us to argue it anymore. If you were going to have an oral argument on it, then I'd need some notice, because I'm planning some time out of town toward the end of October. And I would want to make sure that it met the schedule I could keep, Your Honor.
No, that's a fair point. There are times, I've had it happen before, where we dive into the legal briefing and we identify perhaps a critical issue that might need a little more attention. And sometimes the oral argument can be helpful. So I'm saying today, no oral argument. That's what I anticipate. But there's always that small chance. It's a pretty small chance, but it's there. It's a non-0% chance that the court could request oral argument. I just don't expect it to do so. But I appreciate the heads up on the scheduling issue, and I would have the court administrator reach out and explore that if that it were to happen. So for now, the motion to amend's been granted. We've set 9/23 as the deadline for Mr. James' materials, 10:7 for Mr. Lacy's, and then 10:14 for Mr. James' reply materials. I suppose I should task Mr. Lacy with the drafting the order, granting rather the motion to amend. And I would ask Mr. James to grant the order setting the briefing schedule as to any additional briefing and materials on the dispositive motion that's now pending. So anything further for today? I'll start with Mr. James.
No, Your Honor, thank you.
No,
How about
thank you.
Mr. Lacy?
No, thank
All
you.
right. Thank you very much for your presentations, and thank you everyone for appearing on our court today, and we'll see you next time. For today, we'll adjourn and go off the record. Take care.